I'm Drew Stevenson. This is from my administrative law class. Here I'm going to be talking about the case, the Little Sisters of the Poor, Saints Peter and Paul Home versus Pennsylvania. This is a U.S. Supreme Court case from 2020 that deals with an aspect of administrative agency rulemaking that we study in our course. So let's dive in. First, let's talk about the statutory background here. The Affordable Care Act, or ACA, requires coverage for preventative care for women, quote, as provided in comprehensive guidelines supported by the Health Resources and Services Administration, or HRSA, and HRSA guidelines mandated contraceptive coverage. Initially, they included a pretty narrow exemption for churches. So over time, the Departments of Health and Human Services, the Department of Labor, and the Department of Treasury, which in this case are collectively referred to as the departments, were jointly responsible under the statute to administer the relevant provision of the Affordable Care Act we have here. And so those three departments had worked together to create exemptions for certain employers with sincere religious and moral objections to providing some or all forms of contraceptive coverage for their employees. And these exemptions were initially promulgated with what we call Interim Final Rules, or IFRs, and that allowed them to take immediate effect or have immediate legal force by invoking the Administrative Procedure Act's good cause exception. This practice of using interim final rules is part of the takeaway from our case here and why it's in our casebook. So pay attention to this aspect of our discussion. So after years of extensive litigation, including a previous trip to the U.S. Supreme Court, the departments issued final rules in 2018 that finalized the IFRs, or interim final rule, from 2017. And so Pennsylvania and New Jersey challenged these rules, alleging that they were substantively defective because they lacked legal authority, and procedurally defective because they said that they violated the APA, and therefore, because they were invalid, the exceptions or exemptions for contraceptive coverage couldn't go into effect. And the District Court and the Third Circuit Court of Appeals had sided with the states, issuing nationwide injunctions, and then the Supreme Court agreed to hear the case. But it was the procedural arguments that were really the sticking point in this case that's helpful for studying this case in an administrative law course. We could call this the APA Battleground part of this case, and it presented two procedural arguments against the 2018 final rules, and the Supreme Court rejected these arguments and sided with the government. So what were these procedural defects that happened? Well, first, the three departments that were kind of jointly responsible for promulgating these rules had done it through an interim final rule. And instead of the more classic practice of a general notice of proposed rulemaking under 553B. In other words, an interim final rule might be invoking the good cause exception. And the second defect was that the plaintiffs alleged that the public comment period that followed the interim final rules was just a formality, that the agency didn't really have an open mind or wasn't going to give any serious consideration to changing the rule at all. And they argued this based partly on the fact that the final rule was almost identical to the interim final rule. So let's talk about the holding in this case. The court said that, formal labels aside, regardless of what the agency called or titled what they did, the interim final rules contained all the essential elements of a notice of proposed rulemaking. So all the relevant parties were on notice and could prepare to submit public comments. The APA in Section 553B requires some reference to the legal authority and description of the rules and issues involved. And all of those were actually present in what the departments did. In fact, as far as the holding goes, the Interim Final Rules, the court held, actually detailed all the legal authority under the Affordable Care Act, and they even mentioned RFRA, the Religious Freedom Restoration Act, and aired the relevant issues sufficiently. So there was no prejudicial error. The purpose of notice and comment is fair notice, and the respondent, the states in this case, had the notice, so the claim fails. So even though they said they didn't really have notice because the agencies used interim final rules instead of the sort of classic template of using a proposed rulemaking first and then following it up with a final rule, the fact is that there was no surprise here for the relevant parties. So let's talk about the holding on the second issue. The court held that the Administrative Procedure Act sets the maximum procedural requirements that agencies have to follow for rulemaking. And this is basically the classic doctrine we have under the Vermont Yankee case. And so they are, in a sense, doubling down on the Vermont Yankee doctrine that courts can't add additional procedural steps or hurdles or protections when it comes to rulemaking for agencies beyond what is required in their enabling statute and the Administrative Procedure Act. And that's what the lower courts had done here. The court here was really focused on whether the department had satisfied the APA's criteria from an objective standpoint or an objective viewpoint. And they found that they had, that the government had fully complied with the APA's rulemaking requirements. Now, on the open-mindedness issue, the court said that they declined to evaluate final rules under this open-mindedness test. This was a test that some of the lower courts had started to use to evaluate the effectiveness or the validity or legitimacy of the public comment period in notice and comment rulemaking. Was the agency really already committed, so committed to what they wanted to do that the public comment period was just a pretext or a kind of a sham? Or were they actually going to give consideration to the public comments? And the Supreme Court said, we're not going to try to analyze the subjective intent or subjective thinking of the agencies here. In other words, this was a judge-made rule, a judicial gloss, if you will, with no real basis in the APA for courts to inquire about whether an agency was open-minded enough during the public comment period. And the court focuses instead on whether the department satisfied the APA's objective criteria from an objective standpoint, concluding that they did. They fully complied with all the procedures we would want to see under the APA. They provided adequate notice through the interim final rules. They gave interested persons or parties an opportunity to participate through submitting written comments. They had a 60-day comment period. The final rule that followed up the IFRs had a concise general statement of their basis and purpose, and the final rule was published 30 days or more before the rules became effective. So even though the parties were complaining of procedural defects sort of on from a formalistic standpoint, they were all on notice. There was no ambush or surprise here involved in what the agency did. They all had an opportunity to submit comments as well. Furthermore, the court invoked the prejudicial error or harmless error rule from administrative law. So even if a specific title were strictly required, the states didn't demonstrate that they experienced any harm from the fact that the agency proceeded with an interim final rule instead of a notice of proposed rulemaking, and it didn't harm them at all. So the IFRs had provided fair notice, which was the sort of spirit of the law of the APA. They'd satisfied the policy goals or Congress's intent in the Administrative Procedure Act. So the Supreme Court reversed the Third Circuit's decision and held that the departments involved here actually did have statutory authority under the Affordable Care Act to create these religious exemptions for providing coverage for contraception and held that the rules promulgating exemptions were free from these procedural defects that had been alleged. So the court concluded that the departments did have statutory authority under the Affordable Care Act to promulgate these exemptions. And the court also found or held that it was appropriate for the departments to consider the Religious Freedom Restoration Act of 1993, or better known as RFRA, in creating these exemptions. But now keep in mind, the authorizing statute for promulgating the rules and the exemptions was the Affordable Care Act, not RFRA. And what the states were alleging was that the part of the agency's defect or the lack of legitimacy was that they had referenced another statute that they were trying to comply with at the same time, which was RFRA. So the court said that there was nothing wrong with that when for an agency to promulgate a rule under the authority of one statute and to reference that they think that they are actually required to create the type of exemption that they are by a pre-existing statute. At the same time, the court did not really reach the argument of whether the agency was right that RFRA, or the Religious Freedom Restoration Act, independently required or compelled these exemptions. They didn't have to because they could decide the case based on the fact that it was okay for the agency to take the view that this was a good thing to do under that statute or to comply with that statute. So, in summary, the Little Sisters of the Poor case affirmed the department's authority to create exemptions under the contraceptive mandate of the Affordable Care Act. And even more importantly, I think, in big picture for administrative law, the case reinforced that agencies only have to comply with specific objective procedural requirements of the Administrative Procedure Act when they're engaged in informal rulemaking or promulgating regulations. And courts can't impose additional judge-made procedural hurdles just because a rule is about a hot-button issue or something that's politically controversial. And the court also said that the substance of the notice matters more than the formal label, and that agencies are not required by the APA to demonstrate or put on evidence that they're open-minded enough beyond fulfilling the APA's clear steps. And even though agencies have to give an opportunity for public comment before they promulgate a final rule, they don't have to change their position just because of those comments. They may have to respond to the comments or acknowledge them in their final rule, but they can have the final rule be exactly the same as their original proposed rule or interim final rule if they want. There's nothing in the APA that forbids an agency from sticking to their guns or doubling down on the administration's policy commitments like they did here. Let's talk a little bit about the aftermath after this case. Note that the 2017 interim final rules had been enjoined. So the courts had basically issued a nationwide injunction, meaning that the public didn't really have to live under them while commenting on the final rule. And that might have influenced the justice's view in this case, that because of the preliminary injunctions that kept the IFR from going into effect immediately, it became a de facto proposed rulemaking. In some ways, part of the legacy of this case is probably going to be that agencies have more leeway to use an interim final rule as their procedural mechanism for rulemaking, as long as they follow it up with a public comment period and the final rule. In other words, they can invoke the good cause exception, that they don't have to propose the rule first and then wait for the public comment period before there's a rule that can be implemented. They're more likely to be allowed to just announce a rule and have it go into effect as long as they're going to have a public comment period that's followed with a final rule that's promulgated after the comment period. And that concludes our discussion of the Little Sisters of the Poor case. Thanks for watching.